Okay, here we go. We got question 2 from the 2023 February bar exam. And let's take a look at the call to question. What constitutional challenges right there? The examiners let you know it's constitutional law, possibly criminal procedure. Can the Attorney General make to the act? Uh-oh. I know the president's up to something when I see the word act. I mean, that's just that screams president, Congress. And are they likely to succeed? So what constitutional challenges can the Attorney General make to the act? And number 2, does NASDA have standing to intervene? Oh, intervention. Wow. If intervention is part of civil, wow, how about that? So many of these things dovetail. And what we did on the last was kind of UCC, torts with joint and several liability, civil procedure. So these subjects really do go together, and it makes logical sense why that is. So let's take a look. We have standing to intervene. So let's take it from the top. And for interest of full disclosure, I hate constitutional law. It's the one subject that I'm not fond of, probably because it's like Harry Potter. It's all made up. In response to significant rise in diabetes among school-aged children, and based upon links between diabetes, exercise, and diet. By the way, I don't know if you know this, but I think it was Michelle Obama that had a significant hand in this. In fact, there was an actual MBE question and I think you guys got on the last bar. Do you remember the MBE question about they weren't allowed to sell candy in vending machines, and Congress said that no more candy in vending machines? Okay, does anyone remember that? Okay, I see. And that's part of the Commerce Clause, because vending machines are retail, it's economic, and it has it has the Wickburn versus Filburn, or whatever the case is, 1943, about how it could substantially affect interstate commerce. Okay, and by the way, Michelle Obama, so what exactly happened, and that was Michelle Obama that was behind you trying to get fruits and vegetables and actually things that are more healthy in the schools. I personally love vending machines. I got no problem with it. Okay, Congress had passed and the president has signed. So we have no presidential veto. We have no 2/3 or anything like that. They're saying that's a non-issue. The Child Physical Education Act. Yeah, let's get those kids out there. Get off your phone and go exercise. I like it. The act, administered by the Federal Department of Education, okay, provides significant additional funds to states for public schools with daily physical education classes. Okay, so that is regulation through spending. So Congress, well, here's the thing. I actually was talking to my tennis coach about this today, which is ironic. We were speaking of it. So I don't know if you know this, but there's federal rule. You know what federal freeways are? As part of the Federal Freeway Act of the 1920s. And you know the 5 freeway and the 10 freeway? You know how they have that blue and okay, those are federal freeways. That was part of the federal program back in the 20s. And what federal government said to states with freeways run, everyone's got states, every state has freeways running through it that are federal freeways. And the federal government said, if you keep the drinking law at 21 years old, we will give you funding to keep those freeways in good repair. And the only 2 states was Louisiana, and I forget the other state, that did not raise its drinking age to 21. And that's why their freeways were so poorly maintained, because Louisiana as a state had to pay its own money to maintain the freeways. They weren't getting federal funding. I don't know if they've, what's that?
I think it was South Dakota too, because there was a case. Yeah, there was a case about that anyway.
Yeah, ironically, he did bring up South Dakota, but in a geography sense, so that might be it. But it's interesting though, how that works. So this is regulation, and thank you, Erica, for that. Regulation through spending. These funds are to be used for the hiring of additional physical education teachers, good, and purchase of physical education equipment. That's great. Wow, I kind of got through that first paragraph without a hitch, right? I mean, was that whew, I'm waiting for the snowball to hit me, and it hasn't yet. So that's not bad. Because what I did hear from students on the exam is that this was the most difficult essay, and then call 1 in question 1. And I can see that. Let's see what else goes on here. Testimony before Congress. By the way, does anybody know what power Congress has? It's actually part of congressional powers to force you to testify in front of Congress. They get Zuckerberg there and whatever. Does anyone know what that power is called, Marissa?
Isn't that the investigation power?
Yeah, investigatory power, exactly. Okay, but they're not getting into that. As revealed that on average, public schools spend only 25% of their school lunch budgets on fresh fruits and vegetables. And as we all know, that's way too much. We need more chocolate and candy. That's what I'm a big fan of. For those of you that know, like I'm a big snacker on chocolate and ice cream. The act requires that states accepting the funds must enact. It requires that states accepting the funds must enact legislation setting as a minimum that 50% of public school lunch food budgets be allocated. Okay, so what you might think to yourself is, this is commandeering under the 10th Amendment, because the federal government is forcing the states to enact legislation. But the way you get around that, because they're regulating the states and they're telling the states, forcing it, but they're regulating it through spending. And I don't think 25% of the lunch budget is too significant as to like be what's the word they use? Not unconscionable, but to be what's the word they use when they say here when Congress kind of like oppression or unconscionable or whatever. Anyways, this is fine. This is just regulation for spending. So I would talk about the 10th Amendment commandeering. And here's the thing that you hear a lot of times from other courses or professors that at your law schools that might teach you, like, oh, always discuss state action and standing. And the answer to that is incorrect. Because here's the thing, if you're implicitly required to discuss standing, then why would they expressly ask for it in call number 2? Think about that for a second. If you're automatically required to discuss it, then why in the world would they ask expressly about it for number 2? That doesn't make sense. So that's why when I say the state action and standing, it's not that big of a deal. And so I don't think in call 1, you even need to do it, because I can't imagine how the Attorney General doesn't have standing. I wouldn't even discuss standing in call 1 or state action. Okay, so we have 10th Amendment commandeering, regulation through spending, and so far, so good. And I have to think to myself, I got 2 more paragraphs going on, and I better get some issues, because those issues are going to take me about 10 minutes. What am I going to do with the rest of the 40 minutes? Oftentimes, by the way, students say that they're like, what if I forget everything? Well, then guess what? Then you're going to have no problem finishing on time, are you? And then they're at the same time, and the next thing they say to me is, what if I go over time? Well, then you don't have to talk about it, so you must have known it. So the two don't go hand in hand, and you guys can end up worrying about everything. And most of the time, the people that don't make excuses and do the work, they're going to pass. They have definitely the competence of passing. When you start making excuses, not doing anything, that's when you're going to have trouble. All right, so let's move on to the third paragraph. Testimony has also revealed that rates of childhood diabetes tend to be highest in minority and low-income communities. Now, we don't know what the correlation or the cause of that is. Why do minorities and low-income communities have higher diabetes? So is that suggesting they have a poorer diet? That maybe they can't afford to eat healthy? I mean, chicken breasts are $2.50, a banana is 90 cents. So I don't know what the correlation with that would be, but I assume they're getting at race. And anytime race is no. The act has significant additional subsidies for public schools where the majority of the student population is non-Caucasian. Oh, so are they actually singling out schools? Like, is that just, here's my question. Is the purpose of the law to really focus on minority, non-Caucasian schools? And is it actually expressly states as they act as significant additional subsidies? Yeah, so that would be, okay, so that's, does anyone know what the issue is there? We're talking about race, we're making a classification. Somebody raise their hand and let me know. Go ahead, Omar.
Is that equal protection clause?
And that's what they would want you to do. And you wouldn't be wrong. It's actually due process. You know why? Because the equal protection clause does not, or the 14th Amendment does not apply to the federal government. The federal government is governed by the 5th Amendment due process clause, which has an implied equal protection in it. Now, Amir, that's just semantical, really. So if you put equal protection, it's fine. But technically, it is the 5th Amendment due process clause. And here we have, you would need, because this is race, we're going to need strict scrutiny. assuming that, I mean, because it wouldn't say significant additional public subsidies. So yeah, that's a race-based classification. And I don't see a compelling reason, or nor do I see it's narrowly tailored. No, I don't see how this would survive. Okay, well, so far so good. Like I'm like almost breathing heavy to the fact, like, when am I gonna get knocked out here? When's Tyson gonna punch me? Okay, before the act had gone into effect. Oh, before it had gone into effect. Interesting. Oh, but it's imminent. So it's still imminent, and I'm thinking about that with standing. State X, through its Attorney General, has brought suit in federal court seeking a declaratory judgment that the act is unconstitutional. Okay, that's fine. So maybe you do talk about standing there. State X. Why would state X? What is state? Wait, how would wait? State X through its attorney. So we have the Attorney General of State X saying that it's unconstitutional. I would think, now believe it or not, I would think you would have to talk about standing because it's imminent. And the fact that, well, are they not getting the funds? I mean, like, I don't understand what they're, they're actually, they probably do have standing because this is a race-based classification that's not going to stand. The NASDAQ, National Association of School Dietitians, is that a real thing? Does anyone know? Is that a real thing? I mean, I have to Google it, but I'm wondering if that actually, I'm sure it is a real thing. Is seeking to intervene in the Attorney General's lawsuit. Why? What are they trying to intervene for? According to their charter, it seeks to promote healthy diets for school-age children, especially through lunch programs. So this is part of their purpose. All right. And you only need one representative. The Attorney General opposes their intervention. How in the world, why would they intervene? I don't understand. What are they trying to, I mean, there's nothing. I don't get that. So just because this is part of their purpose, you already have the Attorney General of State X seeking to say it's unconstitutional. Oh, because they want to keep the law. I don't see how. No. So what they can do is, you know what, I would assume they'd write an friend of the court, what's it called, amicus curiae brief on behalf of Congress and help out Congress, but I don't see how they would be able to intervene. So whether they have standing, I would say no. That's it. This can't be it. You know, okay, so let's go to call one. What constitutional challenges can the Attorney General make? That there's commandeering, but then that's going to be knocked down through regulation through spending. You have the Fifth Amendment. I have to read it. I would like to read this 2 more times. I'm not going to do so in the interest of time. But I would have to think to myself, wait a second. Was there a 14th Amendment Section 5 where Congress can point to a pattern of discrimination and regulate the states? So, okay, so there is a section, and honestly, I probably would have missed that. And the only reason I'm even bringing it up now is because I did hear, birds chirping about it and looking at it now, because I have to assume that I forgot something. So Section 5 of the 14th Amendment may give Congress, I doubt it will though. It's got a possibility to regulate, like to place restrictions about the Equal Protection Clause on the states if they can point to a pattern of discrimination. But just because that minorities and low-income communities, I don't think that it has to be pretty much for Section 5 of the 14th Amendment for Congress to regulate the states. It usually has to be a fundamental right or involve gender. And I don't see, or like a racial-based classification. And I don't think this would qualify because they're not being discriminated against. Okay, so those would be the constitutional challenges. I thought something was about the president. No president here. Does NASDAQ stand to intervene? I can't see how. I don't see what. I don't even know what to even answer in number 2, because what could they bring to the table that Congress cannot argue themselves? Because I assume they're suing Congress, right? Or suing, federal government. You have to sue the federal government. Okay, so there's my recap of call number 2 or question number 2. I do feel a little naked in the sense that something just doesn't sit right. Like I just don't feel like I I got everything and there's something I'm missing. I don't know what it is right now. And that's why I'd have to read it 2 or 3 more times. But I'd love to hear what you guys have to say. Let's open it up for discussion. Comments, critique. Go ahead, Amir, please. Thank you.
For question 2, is it good to discuss intervention based on Federal Rules of Procedure number 24?
No, because they're asking about standing. That's a good question, actually. Would there possibly be intervention? God, I don't want to say no. My gut instinct to say no, but I'd have to think about it.
Because they have interest in the outcome of the case, and nobody is representing on their behalf.
But they don't have to. Why would they have to? That's my thing. That would be the standing argument. So let's do this. Okay, come on. Get over there. I'm going to pull up Rule 24. And let's share my screen. Let's take a look at that. Okay, Iris, Amir, Marissa, and Mark. Can you guys see this? Okay, got it. Intervention of right. On timely motion, the court must permit anyone to intervene who is given an unconditional right to intervene by federal statute, not here. Claims an interest relating to the property or transaction. They have no interest in this. I mean, do they have an interest in it? And so situated the disposing action may as practical. No, they're not going to impair or impede their ability to protect its interest because this is up to Congress. And permissive. The court may permit anyone to intervene who is given a conditional right, okay? Has a claim or defense now. No. So, good question, Amir. I would have to think by government fish, no. Okay, notice, okay, go. Whoops. Whoop. Okay, I would have to think that's just a standing argument, not a motion to intervene. So good question, though. Great thinking about it. Did you discuss that? Did anyone discuss intervention on the exam? Raise your hand just like this if you did. Okay, a couple of you did. What else did somebody discuss, or somebody who hasn't taken this would have discussed that I missed? Kindly let me know. I'd love to hear it. Did anyone discuss it? Go ahead. Go ahead, Marissa.
Sorry, I don't know if this is right or not, but I put ripeness because it said before the act has gone into effect. So I didn't know if that was something that I needed to discuss or not.
Okay. And so my thing was like when I got into the standing argument, the case or controversy is because it's imminent. So it's, the act has already been like put together. It's been approved by the president. So it's going to take effect any day now. Because here's the thing, actually, some federal laws, I think if I'm not mistaken, and somebody correct me on this, I believe all laws, state and federal laws, are enacted on January 1st and June 1st, if I'm not mistaken, like every 6 months. Is anybody aware of how that works? So like new laws come out June 1st and like every 6 months, January 1st. So let's just say that this was all passed in September. Well, it's going to be an act. It's going to come into effect on January 1st. So it is imminent. So the ripeness argument, did you say that it wasn't ripe?
I said that it was ripe.
Yeah. Okay. I can see that. I can see that. I would have discussed it on the imminency requirement for standing, which didn't make sense why I'm discussing standing twice. So Nika, I actually think you're probably right on that. It probably could be to do with ripeness, interestingly enough.
And then another thing I discussed was since they discussed charter schools, I kind of compared charter schools to public schools, but I might have gone too far with that.
Well, it's interesting. And this is why reading it once is not, I would highly recommend, please read the fact pattern on the bar exam at least 3 times. Because I'll tell you why, Nika, I never even saw the word charter school. Where do you see charter schools? No, seriously.
It's the NASD's charter. According to the
charter. Oh, it's charter. Like that's his bylaws or it's mission statement.
Oh, okay.
A charter school. What is a charter school, by the way? I don't have any kids that live. So what is a charter school?
I thought it was a private school versus public school.
I think it's something different. Does anyone know what a charter school is? Does anyone have a kid at a charter school that knows what it is?
Charter schools are usually publicly funded as well. They're usually public. They're just a different branch because they have to abide by the same state laws. They get state funding. So yeah.
Okay, now I know.
I do recall, because they're not a school. They're actually looks like they're an organization.
Okay.
So but thanks, Nika. I mean, like we also, again, While reading it several times, like, oh, it's their charter, right? Okay, but that's good. Now I'm glad I didn't, I'm sorry, but at your expense, I'm glad I didn't miss charter school. I'm like, I remember reading that.
Yeah, no. Okay. Well, now I know.
Anything like, and please chime in and don't feel embarrassed if you discuss something that I didn't.
I talk about the private and public school just shortly. I don't know if it was right or not. Because they
Oh,
all,
like,
yeah,
I'm sorry.
yeah, because they mentioned the public school, so I discuss it at private versus public school. So I don't know, just a short discussion I had.
I did that too. I don't think I said NASD's charter, but I think she's right. I did that.
Okay. Okay, let's take a look
Oh.
at paragraph. Go ahead.
No, so sorry. Just how private schools are being left out of the funding.
Okay. And what would so that'd be an equal protection due process classification, which I don't disagree at all. I didn't, it says public school lunch food. So they're not giving fundings to private school. But here's the thing, there's no private school here. That's, maybe the Attorney General of State X is also bringing it on behalf of the private schools, you don't know. So, in that case, you would give it what, Nika? What kind of scrutiny?
Is it intermediate?
No, it's not gender.
No, I did a rational basis.
Yeah, it's a rational basis.
Okay.
Here's the way that you can really look at it. As a baseline, everything is rational basis, except for race, fundamental rights, and gender. That's it. So instead of remembering all, just everything is rational basis, unless it's men and women, racial classifications or any kind of fundamental rights. Then that's it. So there's only those very limited categories that get anything other than rational basis. And if you think about it, we have to allow the government to regulate things, because or else, everyone would be challenging it, but they can't do so based on race or gender, because, those are exclusionary categories. And they can't impinge on your fundamental constitutional rights. Okay, so we're going to wrap up here unless someone else has something to add. And I really do appreciate the commentary and discussion. Go ahead, Marissa.
So I did talk about regulation through spending and commandeering, but then I was like, oh, maybe Congress would also have the argument that they're regulating under the Commerce Clause. I didn't have time to really talk about it because there was so much to talk about, and that was kind of a secondary thought, but I think I did jot it down on my actual answer.
Okay. They only need one power. They don't need two. Carmen, they're not really regulating what am I doing? This would just be regulation through spending, one of their permissible powers. I don't see Commerce Clause here. I'd be interested if it is there. I don't see it though. But I like the way you guys are coming up with things, because I'll be honest with you, I would barely fill the hour here. I'd probably be at the 45-minute mark going, what did I miss? Did anyone else feel like that? Or like anyone else? Yeah. This wasn't as well, I'm saying that now until I read the answers. I'm like, oh shit. I don't think this was as difficult as people made it out. The one thing that I would have missed Section 5 of the 14th Amendment. And if that public versus private thing, I could see that being a rational basis argument. And it makes sense, because here's the thing, Nika, because we know we're going to discuss strict scrutiny for the racial-based classification, they're not going to test the exact same thing twice, which is also why I believe your rightness argument had some merit to it, rather than discussing standing twice. So if they're going to do strict scrutiny, well, they're going to do intermediate or rational basis on another classification, which makes a lot of sense, and why I kind of agree with the public versus private. And that went over my head. So I actually probably do think there's a public versus private argument here. All right, and that starts to fill the hour. Everything has to have the feel to it. Okay, great. Thanks for the great discussion of number 2. And again, once they release the answers, most of you guys won't care, because you'll be practicing law, getting your business cards printed and asking for a raise, which congratulations. But for me, in order to teach better, I need to make sure that I'm reading all that stuff. Okay, we're going to move on to the next one.
Can I add one more little